Good evening, ladies and gentlemen. The time is now 6 p.m. I'd like to call this meeting to order. At this time, I'm going to request all those who can stand, could you please stand so we can say the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic to which it stands, one nation, under God, indivisible, for liberty and justice for all. Can we have a moment of silence, please? Thank you. You may be seated. At this time, we have some new members that we need to swear in.
Yes, thank you, Madam Chair. For you new members, my name is Patrick Brackens. I'm the attorney for the Code Board, so I'm not the city attorney. The city attorney represents the Code Enforcement Division. I am the attorney hired to represent you, the board. At this time, under Florida law, I do have to swear in our new members. I'll keep it fairly casual. You do not have to stand. I would just simply ask you to raise your right hand and repeat after me. I state your name.
Bill Kilburn.
Do solemnly swear or affirm
Do solemnly swear or affirm
that I will support the Constitution of the United States of America,
that I will support the Constitution of the United States of America,
the laws of the state of Florida,
the laws of the state of Florida,
and the charter and ordinances for the city of Clermont,
and the charter and ordinances for the city of Clermont,
that I am duly qualified to serve
that I am duly qualified to serve
under the Constitution of the state of Florida
under the Constitution of the state of Florida,
and the charter for the city of Clermont,
and the charter for the city of Clermont,
that I will well and faithfully perform
that I will well and faithfully perform
the duties of the Code Enforcement Board,
the duties of the Code Enforcement Board,
so help me God.
so help me God.
Thank you and welcome.
Thank you very much. Ray, could you do the roll call, please?
Member Mikowski,
Here.
Vice Fracasso, Vice Chair, yeah. Member Kilburn,
Here.
Member Connelly,
Here.
Chair Camps,
Here.
Member Cornett,
Here.
and Member Fornolls.
Here.
Thank you.
At this time, the members that were here at the last meeting, I'm sure you went over the minutes, and do I have a motion to pass the minutes as they stand?
Motion to approve the meeting minutes as they are stated.
I'd like to make a correction.
Yes, sir.
It's item number 8. It shows Member Fornolles as both making and seconding the motion. That's not correct.
Then as the motion wasn't seconded, a new motion to approve the minutes as amended would be appropriate.
Do I have a motion to approve the minutes as amended?
Motion to approve the amendments as amended.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Motion approved. Okay. Okay. At this time, I'd like to welcome everyone to the September 15th, 2025 City of Clermont Code Enforcement Board meeting. Before we begin, I would like to advise everyone about the procedures that govern the appearance before this board. This meeting is open to the public under Florida government and the Sunshine Law. The Code Enforcement Board is acting in a quasi-judicial capacity when considering individual cases. However, every effort will be made to hear all persons having relevant evidence or argument to offer in accordance with the rules for such proceedings. We ask that each person who speaks before the Code Enforcement Board sign the sign-in sheet located on the table in the front, right here, please. After the opening remarks, all those who intend to speak today will be sworn in or affirmed. When asked if a respondent is present for your case, please come up to the podium. All proceedings before this board are electronically recorded. Please speak directly into the microphone at the podium and state your name and address clearly for the record. Additionally, please limit your comments to only information relating to the case being presented. The City of Clermont has the burden of proving a violation exists. The city presents their case, and then the respondent presents theirs. Once all cases where respondents are present have been heard, the board will then hear the remaining cases. Each party may question witnesses offered on behalf of the other party. Additionally, the board members and their attorney may question those appearing before the board. This board will then make its decision based upon the evidence and testimony presented by both parties. The board's role is to determine if a violation exists, and, if so, in most cases, set a date for the violation to be corrected and set a fine if compliance is not met. It is not the board's role to advise you of a specific method or act that you can take to come into compliance. The Code Enforcement Board is appointed by the City of Clermont to review alleged violations of the City of Clermont Code of Ordinance fairly and objectively. Its members are volunteers and not employed of the city. The board's authority is limited to determining if a violation of the code exists. It does not have the authority to change the codes or ordinance. Although you may have evidence, argument, or circumstances that could justify being excused from compliance with the applicable code, you are advised that this board does not have the authority to grant you an excuse. Such an excuse is commonly referred to as a variance or exemption and may be granted through other procedures such as applications to the city, but not by the Code Enforcement Board. To avoid interference with cases being presented to this board, all cell phones are to be turned off or silenced while in the chambers. Okay. Okay, I believe, do we have anyone here who wishes to speak before the board? Could you please stand and raise your hand as you be sworn in?
Are we doing the swearing in of witnesses?
Yes,
No?
yes, sir.
Okay. So at this time, if you are here for a case of yours where you're the respondent, or if you're here to speak about a specific case that's on the agenda, as these are quasi-judicial hearings, I have to swear in all members of staff, any person who's going to testify on a case. If you were just here for public comment about an item that's not on the agenda, you do not have to be sworn in. So if you're here for a case and wish to be sworn in, if you would, if you're able to, please stand and then raise your right hand. Do you swear or affirm, I see you stand, there you go, you can raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. All right. If, thank you, you can be seated. If one of you that didn't stand or didn't raise your hand determines that I do want to speak on an issue, and you want to come up and you've not been sworn, hopefully I recognize you have not been, but I would ask that you say I was not sworn in, and then I'll quickly swear you in, and we'll get on with your business. Thank you.
Okay.
Good evening. My name is Avery Dyan. I am the Assistant City Attorney. I'm just going to go over the agenda for tonight's proceedings. First, we will do item 1, which is case C24120006, Colonial Tile and Paver LLC. Then we will move on to item 2, case number C25010036, Lake Mineola Condominium. Then item 3, case number C25060009, Southern Villas Lot Owners Association, Inc. And item 4, case number C25060012, Edward Emmerich III. All of those will be at reduction of fines. Then we'll move to new business, starting with item 5, which is case number 25-0000008, Sunshine Properties LLC. Then we will move to item 6, case number C2412-0007, that's Reina Ortega. And finally, item 7, case number C2505-0017, New Beginnings Central Florida, Inc. Thank you.
Good evening, Board. Andrew Snodgrass, City of Clermont Code Enforcement. All right, this is case number C2412-0006. This is a fine reduction request from Colonial Tile and Pavers. This was for City Code Section 125-522, building permit required. The last Code Board hearing was on March 17th. The finding of fact was sent out March 20th. The finding of fact was delivered. That says March 20th. I do have a USPS receipt. It was March 26th, so I apologize for that error on there. Affidavit of compliance was sent out August 18th, 2025. This is the finding of facts from the March 17th board. This is the affidavit of compliance once the property was brought into compliance. This is the fine reduction request from the owner. I know this was included in your packet. Hopefully everybody had a chance to read this. This is the secondary fine reduction request received. So a quick case summary. It was opened in December 6, 2024. Board set a compliance date of April 16, 2025. Property was brought into compliance on August 5, 2025, resulting in 111 days of accrued fines. The fine amount was set at a rate of $250 per day. The grand total of the accrued fines was $27,750. Staff recommendation is have the fine reduced to 20% of the total fine amount and to have the reduced fine amount paid within 30 days or have the fine revert back to the original amount. The original amount being $27,750. Staff recommendation of 20% is $5,550. That 30-day compliance date for the staff recommendation is October 15, 2025. I have nothing further. Any questions for me?
Any questions from the board?
I believe
Do we have someone here
I
that
believe a
represents?
representative is here from Colonial Tile and Pavers. Did they show?
Do we have anyone here from Colonial Tile and Pavers?
Okay, well, I apologize because I believe they signed in, but with nobody present on their behalf, normally we don't hear fine reductions if they're not present to state their reasoning.
I'm sorry, sir.
Normally, we do not present fine reductions if a respondent is not here to request the fine reduction, and they are aware of that.
Is anyone present for this item? Because what I would recommend the board do is you table it to the end of your meeting. If they signed in, somebody's here. And so what the city represented to you that the city typically brings these fine reduction requests when they're applied for by the respondent. When the respondent comes and explains to you why they either want you to rescind or reduce the fine, and the city has a recommendation for what they recommend the fine be reduced to. But if there's no one here to request it, then the city typically does not request a reduction in the fine. So my recommendation would be that you table it to later in your meeting in case someone is present.
Okay.
I'd like to go ahead and make a motion then. I move that case CEB C2412-0007 12-0006 be tabled to the end of the meeting.
Do I have a second?
I second.
All in favor?
Aye.
Motion passed.
The next case is number 2 on the docket.
Yes, it's case C-2501-0036. This is Lake Minneola Condominium Association's a fine reduction request. This is for unsafe structures, stairways, decks, porches, and balconies, unsafe conditions. The code board hearing was on March 17th. The finding of fact was sent out March 20th. Finding of fact delivered April 8th. The affidavit of compliance was sent out July 28th, 2025. The finding of fact from the March 17th board. This is the affidavit of compliance, once the property was brought into compliance. This is the first sheet on the fine reduction request. And this is the attachment the fine reduction request refers to.
Do we have anyone here to represent Lake Minneola Condominium?
Yes, we do.
Could you please come to the podium?
So a compliance date was given by the board on May 16th, 2025. The property was brought into compliance on July 22nd, 2025, resulting in 67 days of fines accrued. The fine amount was set at a rate of $250 per day. The grand total of the fine is $16,750. Staff recommendation is to have the fine reduced to 20% of the total fine amount, to have the reduced fine amount paid within 30 days, or have the fine revert back to the original amount. The original fine amount being $16,750. Staff recommendation 20% is $33.50. And 30-day compliance date would be October 15, 2025. Nothing further from me if you have any questions.
Okay, ma'am?
Good evening, council members and city staff. We are here representing Lake Minneola Condominiums as the board of the association. My name is Colette Keno. We had ahead of time provided a letter to some council members via email. We have copies if anybody would like a copy that we delivered to your city earlier. We are actually here in asking for a reduction or waiver of our fines that we have incurred in the 67 days on this structural repair. We were given 45 days to be able to get an engineer, get a company that we could get to come out and represent our association both on the cost and who would properly do these repairs, that the city would pass our permitting and our inspection. And we've done everything diligently from the moment that you have presented this violation to us, and it was not easy within 45 days to have an engineer draw up plans, get them to a construction company, get them to the city for permitting. We understand we did have some downtime with the city with permitting due to low staffing in your fire department, which held us up a few weeks. And we're just presenting this to you that we've been in the city of Clermont here for over 50 years with Lake Minneola Condominiums. We've never had a violation within the city ever since we have been here. We're a small community of 10 owners who have endured not only a lot of assessments since the hurricane came, because we had a roof taken off, and we did step aside from this repair because that, at that time, had been a very priority for us to make sure we could get it done. We never were ignoring the situation, but we did put it aside. We never wanted to be in this position. Unfortunately, we had a resident who saw some things deemed possibly unsafe and filed the complaint, and we've done everything that you guys have asked us. And I mean, ultimately, we're looking for a waiver of these fines, but we really would like to find, working together as a community in the city together, that we've all been here for many years together, to reduce our fines for us sufficiently, as we've had many assessments come down to a lot of our owners, which we only have 10 at our Lake Mineola condominiums. But everything has been satisfied, everything has been signed off, and we are in compliance with you as a city.
So at this time, they are in compliance?
Yes, they are in compliance.
Does anyone have any questions?
Mr. Snodgrass, is it in your experience, is engineering delays a factor in some of the delays in getting work accomplished?
Permit delays can happen depending on documents that are required, depending on staffing, as said. Sure, that's in every aspect of every job, yes, delays can happen.
The lady mentioned that there was a delay, was it
The
fire
delay from the, I
inspection?
believe,
I
said,
understand it was the fire division within the city that they were short-staffed, and we have if you ever need to provide any emailing or documentation from the construction company that communicated, and we've been in good communication, I believe, back and forth on making sure this project was not ignored on either end, so we do have all that back and forth from Mr. Snodgrass from the city and our construction company and how that happened.
Thank you.
Mr. Snodgrass, is the original complainant, is he here, is he here this evening? He is
I do not see him,
Okay. Back to you, you said 10 homeowners. I thought the association was multiple buildings, is that correct?
We're 2 buildings, 12 units, but there are 2 owners that
Okay.
have 2 units.
Gotcha.
each.
All right, thank you.
And we do have we have about 3 or 4 people who do live there that are on fixed incomes as well. So we've had already 3 assessments from the hurricane and pole repair, and so this is gonna take a big toll on some of our members that live there.
I'd like to make a motion. In case number C 2501-0036, I move that the fine be rescinded, and if there is a lien, that it be released.
Do I have a second?
So moved.
so moved.
Any opposed?
Well, a second, so then you call
Okay.
the vote.
Excuse me. All in favor?
Aye.
Aye.
Any opposed? Motion passed.
Thank you.
Good evening, Code Enforcement Board. Joshua Cortez for the City of Clermont Code Enforcement. Welcome new Code Board members. This is item 3, case number C25060009, Southern Villa Lot Owners Association, Inc. This is a fine reduction request. This is a screenshot from the property appraiser's website showing the property's location. This was the notice of hearing that was sent out initially to the respondent. The violation notice that was sent out to the respondent. This is a repeat notice of violation. This is a respondent who has been before the Code Enforcement Board before for these violations. This was the finding of facts and order that the Code Enforcement Board had put in place at the July hearing. This is a copy of the respondent's reduction request form. I understand that you had that in your packet, so I'm going to move on from this. This is a picture that was taken when the case was first started, showing the overgrowth. And this is a picture from this morning. The case summary and staff recommendation. So this case was heard by the Code Enforcement Board at the July hearing. The property was brought into compliance on June 29th. The total days in violation were 13 days. The fine that was imposed by the board was $6,500. The staff recommendation is to reduce the fine to $500 to be paid within 30 days or have the fine revert back to the original amount owed. I have nothing further if you have any questions for me, and the respondent is here.
Please state your name and your address, please.
Hello, I am Austin Pownell. My address is 665 Villa Court, Clermont, Florida, 34711. Good evening, members of the Code Enforcement Board. Thank you for giving me the opportunity to speak tonight. My name is Austin Pownell, and I serve as the treasurer for the Southern Villas Lot Owner Association. Our community has been managed by Greystone Management for more than 10 years, which is long before I joined the board. They are supposed to handle communication with the city and oversee the maintenance of our common property. Unfortunately, their failure to communicate and manage properly is the reason why this violation turned into daily fines. Here's how it happened. On June 3rd, Greystone emailed the board saying the issue was with an unmowed drainage ditch. We immediately had it mowed and added into our landscaper's contract. At that point, we believed the matter was resolved. Then, on June 19th, Greystone's outgoing manager emailed saying that the retention pond area wasn't up to standard. He downplayed it as just another landscaping matter the landscaper would handle the next day. At no time did he mention that this was an active code enforcement violation, and at no time did he say that $500 per day fines had already started accruing. After that, the board heard nothing further until July 10th. On that date, our new manager, Angela, emailed saying that we had to appear at a code enforcement hearing on July 21st. That was the first time the board was told this was a code matter. By then, fines had already accrued for 13 days, and we were left with only 11 days to prepare for the hearing. Worse, when asked for clarification, our manager admitted she didn't know what the violation was for exactly. She even called the notice vague and downplayed the seriousness. From the board's perspective, we acted in good faith when first told of an issue. We thought it was resolved, then we heard nothing for almost a month. And suddenly we were told to appear before you, all while fines had been quietly building. Hardship and reduction requests. Our community is made up of residents who are mostly elderly and on fixed income, and new families who are just starting out. A fine of $6,500 is going to cause serious hardship for our residents. Even small increases in dues are felt immediately. That's why this board respectfully requests that the fine be reduced to an amount we can afford of $500. And we are very grateful that Officer Cortez has recommended that reduction, and we were prepared to resolve it promptly. And here's how it won't happen again. Since the last hearing, I've taken direct steps to make sure this never happens again. I now know exactly where the property is that must be maintained. From the map, it's kind of away from all of our buildings. Board members were not told about it until the July 21st hearing. So from there, I kind of learned everything through Joshua, which thank you very much, Joshua, for doing that. I'm very appreciative. So I know exactly where that property is now. If I had been told at the time, you know, when the very first warning came in on June 3rd, I could have gone out there with a weed whacker or a mower and just handled it myself in 10 minutes. I would have done it. So since the last hearing, I lost my voice. 1 second. Today, I personally walk the property once a month to inspect it. After my last inspection, I reported that the area needed to be cut. The landscaper has already went out there and cut it within a couple days of me reporting it after my monthly inspection. I've also made sure this property is now permanently included in the contract, so there's no room for confusion with the landscaper. In addition to all of that, I've also had Joshua add me as a contact for Southern Villas. so that any other new notices that come in now will go directly to me, and I can handle it, so nothing will fall through the cracks again. So on behalf of this association, I sincerely apologize to the city and to this board. I regret the inconvenience caused by our management company's failures, and now that I fully understand the seriousness of this, I will do everything in my power to make sure Southern Villas does not appear before you again. Thank you for your time, and again, thank you, Joshua.
Does anyone here on the board have any questions?
I had just one question. When is what is the time frame that you're able to pay that fine in?
Oh, we can pay it immediately.
Okay, thank you.
You're currently in compliance, correct?
Yes.
And during the previous, how many times has your association represented in front of this board?
So, with me as a board member, which has been about over a year and a half, I was at one hearing, which was on July 21st of this year. Before then, I had never heard of code enforcement issues or hearings.
Okay, thank you.
And Joshua did tell me, like, I asked him, like, how many fines have we gotten over the years, and he told me 7 over the last 8 years. So, it is a bit interesting finding that out.
I see. So at this time, we're asking for the fine to be reduced to 500?
Or waived if possible, but 500 is affordable, and I understand the city has time and resources that need to be paid for.
Okay. Do I have a motion?
I have make a motion, would this be a rescission of the fine?
Reduction,
Reduction?
yes.
Okay. In case number C 2506-009, I move that the fine be rescinded and released.
That's not a reduction. Is that what you want to do?
Yes.
I'll second that motion.
All in favor?
Aye.
Aye.
Any opposed? Motion passed.
Thank you very much. Please have a good night.
You too, sir.
Okay, moving on to item 4. This is case number C2506-0012, Edward Emmerich III, Cluster Oak Drive. This is a fine reduction request. This is a screenshot from the property appraiser's website showing the property's location. This was the notice of hearing and violation notice that were sent to the respondent. This was the finding of facts that the Code Enforcement Board had issued with a $4,500 fine, $4,500 fine having been imposed. This was the respondent's fine reduction request paperwork. This was a photograph of the property from when the case first started, and a picture from today showing that the property is in compliance. Staff recommendation and case summary. This went to the Code Enforcement Board hearing back in July. The property was in compliance as of July 2nd. Total days in violation were 9. Fine owed is $4,500, and the staff recommendation is to reduce the fine to $500 and to be paid within 30 days or have the fine revert back to its original amount. I have nothing further if you have any questions for me, and the respondent is here.
Sir?
We're willing to accept the staff recommendation. That's really it. You know, we've been in front of you guys before on this issue. You guys have already seen, or at least hopefully you've seen our letter with respect to this situation. We've worked closely with the city to get these things taken care of. There was at one point a misunderstanding as to what needed to be cut and what did not need to be cut, and the different areas, because some of it appears to be shrubbery, but apparently was grass. I think we've got this figured out now. Other news, we have had our loan approved, and we're gonna start building on this place, because the plans are approved and everything else, and that should be taken care of within the next month or so, so there won't be any grass pretty soon, until we lay it again. Thank you.
Just for the could you just state your name for the record?
Edward Emmerich IV on behalf of Edward Emmerich III.
Thank you.
I am an attorney. I do not do this, but
And your address?
3831 Breckenridge Lane, Clermont, 34719.
Thank you, sir.
May I ask some questions for clarification?
Yes, sir.
Officer Artez, you investigated this current case, which is 2506-0012,
Yes.
and you had two previous cases?
There were two,
C 2405-003, which was a violation identical to this violation?
yes, sir.
that
There were
correct?
two previous code enforcement cases that have gone to the board.
2409-031 or 0031, again, the same violation?
I don't have the case number in front of me, but I don't dispute that that's accurate.
Okay. There was testimony at the hearing the last board meeting, and it indicated that there was a site visit. Were you present for that site visit?
Are you referring to the one with the code enforcement manager?
Well, believe Evie Wallace, is she the manager?
She is.
Yes, with the
I
manager.
yeah, I wasn't there for that one specifically.
And apparently the mayor was there? Okay, may I ask questions of Evie? May I speak with Evie briefly?
And just for the record,
Good
she has
evening.
been sworn. Thanks.
Yes, I was sworn. Good evening, board members. Evie Wallace for the City of Clermont.
Morning, sorry to bother you.
And-
I just wanted to clarify that you did a site visit with the homeowner, or the property owner, and the mayor.
Yes, sir.
How long ago was that?
Within the year.
But it preceded
It was a...
this violation.
Correct.
And it was clear to the property owner what the violations that were previously incurred were.
Correct. Correct.
Thank you.
Does anyone in the board have any other questions?
May I make a motion?
Please.
Out of respect for the staff's recommendation, and only because of the staff's recommendation, in case C 2506-0012, I move that the fine in this matter be reduced to the recommended $500, with the stipulation that the fine will be paid to the City of Clermont on or before October 1st, 2025. Failure to pay the total fine will result in the fine reverting to its original amount in the amount of $4,500.
Anyone second?
I'll second the motion.
All in favor?
Aye.
Aye.
Any opposed? Motion stands.
You'll get an order in the mail, yep. Yep. Yep.
You're welcome, sir. Item 5?
Yes, ma'am. So this is item 5. This is case number 25000008. Sunshine Properties LLC, 831 Oakley Seaver Drive, the lofts at South Lake. This is not a reduction of fine. This is a new case being presented to the board this evening. This case is a little bit different than what some of you may be used to. This case was brought to code enforcement through our fire department. And so a lot of the code sections and references that you guys are going to see probably don't look familiar to you. These are all fire codes that our fire prevention staff are using. So I'm going to briefly run through these. And if you have any questions, please stop me or slow me down, but I'm going to kind of be brief about it. Chapter 18, access to gated subdivisions or developments. The authority having jurisdiction shall have the authority to require the fire department access be provided to gated subdivisions or developments through the use of an approved device or system. Access maintenance, the owner or occupant of a structure or area with required fire department access as specified in other codes shall notify the authority having jurisdiction when the access is modified in a manner that could prevent fire department access. 36-inch clear space shall be maintained around fire hydrants. Standpipe and hose systems are installed in combination with automatic sprinkler systems. Installation shall be in accordance with the appropriate provisions. Hose connections shall be equipped with threaded caps to protect the hose threads. Sensor release of electrical locking systems complying with the section stated shall be permitted. Doors with sensor release electric locking system are equipped with an electrical locking system that is released by a sensor activated by the normal motions of an occupant egressing through that door. The activation of the sensor to cause the electrical lock to release is usually by passive action by the occupant. It's just sort of describing, an automatic egress system essentially. Electrical systems, electrical wiring, and equipment shall be in accordance with the stated code unless such installations are approved. Existing installations, which shall be permitted to be continued in service. Unused openings for circuit breakers need to be sealed essentially. Where required, fire-rated gypsum wallboard walls or ceilings that are damaged shall be repaired and maintained in good, proper working condition, essentially. Standards for fire alarms, the appropriate standards for the installation, maintenance, alteration, repair, monitoring, inspection, and so on shall be to the standards that are adopted by the authority having jurisdiction, essentially. Maintenance, inspection, and testing. Whenever or wherever any device, equipment, system, condition, arrangement, level of protection, fire resistive construction, or any other feature is required for compliance with the provisions of this code, such device, equipment, system, condition, arrangement, or other feature shall thereafter be continuously maintained. Installation and maintenance, waste chutes, laundry chutes, and incinerators shall be installed and maintained in accordance with the code section stated, unless such installations are approved existing installations, in which case they can be continued to used. The bottom of a waste chute shall be protected by an approved automatic closing or self-closing door or fire damper. Chute discharge doors or fire dampers shall be permitted to be held open by a fusible link. That's that for the codes. This is a screenshot from Lake County Property Appraiser showing the property's location. Case summary, the notice of violation was sent July 17th. The compliance date was August 17th. The notice of violation was delivered July 19th. The notice of hearing was sent August 18th. The notice of violation and hearing were posted September 2nd, as the notice of hearing was not signed for. The compliance status as of today's hearing is that the property is not in compliance. So this is a copy of the notice of violation that was sent out. Contains all the codes that were mentioned and a sort of rewording of the fire inspector's report, which we'll get to. This is the USPS tracking showing that the notice of violation was delivered. This was the notice to appear that was sent to the respondent, the affidavit of posting, a photograph of the posted notices on the property. This is the fire inspector's report. So some of these items have since come into compliance, but this was the report that was generated by our fire prevention staff and was sent with the notice of violation. Okay. So as of today, the issues that remain in need of correction have to do with the egress system, the latching devices that are connected to the door are not functioning as intended, and the gate that provides access to the community is not functioning as intended. Those are the two violations that remain in need of correction as of today. The staff recommendation to the Code Enforcement Board is to fine the respondent in violation of section stated, to assess a fine of $250 per day for every day the property remains in violation after September 30th, 2025. I have nothing further, and I do have the fire inspector present. So if you have any questions for myself or the inspector, we're here, and I believe the respondent is here.
Are you here to represent the,
Yes, my name is Tiffany Wellstead. I am the regional manager. I'm the representative for the third-party management company that manages lofts at South Lake for Sunshine Properties.
And I'm Corinne Ettinger. I'm the property manager for the community.
Mhm. I see in one picture that I have here that there's a fire alarm that looks like it's just partially attached to the wall. Has that been corrected?
So all of the issues that are on the original report have been corrected as of today, with the exception of the doors. We have to use a third-party vendor named Dynafire, and they are waiting on the part to replace it. So for now, the doors are unlocked where people can.
Okay,
exit
so
from.
people can,
Oh, absolutely.
yes.
Yeah, and there was a
That's
painting
important.
over one of the sensors, that's been moved as well.
But all of the doors are unlocked and ready to open at any time.
And what about the electrical panel? Has that been repaired?
That's all been cleared, yeah. We never wanted to end up here. We had a lightning strike, and then in the process of repairing that, had a second lightning strike. So we have had to untangle all of these issues with multiple vendors. We've tried to be communicative and include everybody on the emails as we work through it, but unfortunately for us, we have to follow certain procedures that our company lays out, so.
I understand. My biggest concern is the safety of the people that live there. That's my concern. It's also been corrected with the laundry chute?
Yes,
And that-
so, we've had the property since 2021. That's the first we were made aware that there was an issue with that. So we are very thankful that you guys told us about it. So we were able to find a vendor to get that fixed for us. And they actually finished that repair today, right?
This morning, yeah.
How much time do you believe you're going to need to have the rest of the repairs done?
I feel confident that our vendor can have the strike plates corrected by the end of the month.
By the end of the month?
Mhm.
Okay, that's good.
I have a question for our fire inspector. Can you run us through your normal procedure as far as inspecting a property, the time that it takes, or the time that the property owner is given to come in compliance, and then the time then you would then refer to code enforcement?
Yes. So usually when we walk through, we go ahead and we try to do a thorough walkthrough because it's done annually. So we started this process in May. We did a walkthrough. We go through, it takes for that property, it's 5 stories with a parking garage. It takes about an hour and a half to 2 hours to walk through that each time we do a walkthrough. As far as giving them the time, it depends on the issue that's at hand and the severity. We gave them each time 30 days to come into compliance. At that point, I want to say it was 2 months before we reached out to code enforcement and then gave them additional 30 days. and then again 30 more days before our hearing.
Great, thank you.
You're welcome.
And could you please state your name for the record?
Yes, it's Amber Butler.
Thank you.
You're welcome.
Can I ask a question? I'm just confused because this, the report we're here today for, I was under the impression that happened in July, so I'm not sure what happened in May.
May 16th, 2025.
Is when you did an inspection?
Yes, ma'am.
But the report I just don't have any paperwork. Listen, we just want our property to be safe, our residents to be safe. We want to get this resolved.
I understand.
Yeah,
I just wasn't aware of something from May when everything I had was in July.
the reason I asked that question is because in order for the fire department to actually have to get code enforcement involved means that they've had to come to your property multiple times. But what I'm saying though is they were there in May, they did their inspection, they found violations. Here's the list of violations. You have time to correct it. Then they come back in that time frame to see if those items were corrected. They give you another notice. Essentially, they were filling it out by hand. It's just a piece of paper that they tear off. So that's why I was asking those questions, so that there is a process that got us to this point. So that's why I wanted to bring that up. And then obviously, there may have been some communication issue as far as what you guys may have seen from the fire department as far as getting these items addressed. So.
Yeah, I think that's why I'm confused, because if we had our annual in May, if we were given any items, we would have rectified those, but this is all from July stuff. So if there is another report that I don't have a copy of.
And then you leave those reports on site, right? Because it's like a carbon paper, 3-paper setup, or do you guys do it digitally?
This is digital.
Okay, and then so a notice gets mailed to the property owner on record?
Yes.
Okay.
I have a question.
Yes, sir.
So the items listed such as the door locking mechanisms, the missing knockout in the electrical panel
Yeah.
and such, those were initially found on your very first annual visit in May, correct?
For May, yes.
Okay.
Was the gate the same?
I'm sorry?
The gate was at the same time, May?
Yes.
I just want to point out, I'm sorry, she is involved with the July stuff. As a property manager, I was involved with the May situation. We had our annual inspection, following our annual inspection from our fire prevention company. They made us aware of items that needed to be taken care of. I made Amber aware as well. We've been in constant communication. At that time, we employed Cintas to complete all those issues. They completed everything except for one battery for our BDA, and then we had to switch companies because Cintas no longer serviced us. I got confirmation that that was all that needed to be done, and at that point, Amber hadn't been out to re-inspect everything. The day after, we got struck by lightning again, and it completely tore out our system. So ever since then, we have been dealing with all of these issues, so they are two separate things. So we were all the way up until compliance with the exception of the BDA battery, which was scheduled to be replaced and had been replaced but burnt down immediately after due to a storm. Then before we were able to replace it again, we got hit by lightning, which caused this entire section of things that needed to be done. On our system alone, there were 115 codes that came in that our fire people had to take care of, so it was not an immediate day thing that had to be done. I've been in constant communication with Amber, Brian, my fire prevention company, my access control company, and I've been trying to find a trash chute vendor for months. I even asked Amber for a suggestion. She gave me one. They didn't respond. I've reached out to every fire company I could find, every trash company I could find, including ours that does our regular service, waste management. They don't do these kind of repairs. The person that I ended up finding to do the repair, I found on LinkedIn, so thank God. But we have been working very, very diligently. I have an entire packet of communication that has been sent between my vendors, Amber, Brian, and we've been doing everything that we possibly can. These are like 3 situations that unfortunately just happen all at once.
How long the egress doors, how long were they non-functional? And by non-functional, with the sensors being covered and the mechanism, not functioning, you said that you now have the doors unlocked
They've been unlocked the whole time.
since you were notified
Since we
that.
were notified, they've been unlocked. Correct.
So since the day of the
And we've
lightning.
been on fire watch, I'm sorry.
Yeah, we've been on
had a
fire
company
watch for
doing
2
fire
months, and in addition to that, I did fire watch myself, so I was on site for 48 hours. The day that we got struck by lightning, if our access control doesn't work, it automatically reverts back to being unlocked, so you could come in and out either way without any type of locking mechanism or anything like that. It would just revert back to a normal door where you would have to lock it manually.
Thank you for all that detailed information. I actually do empathize with you. I manage commercial real estate, and as part of that, we do some asset management on multifamily, and ran into that same issue.
We're not those people.
No, I ran into that same issue with the lightning strike on one of our multifamily buildings, and it took every bit of 60 days just to get everything. It just goes through everything,
We also
yeah.
have our fire company, they are bidding out to do a grounding of our building or something,
Yeah.
so we can try to prevent this in the future. Apparently, this is a
That's a
lightning
very
alley
good idea.
in
Yes,
Clermont. Did not know that.
state of Florida is the
I knew
highest
Fl-
lightning.
I knew
in-
Florida was like lightning capital, but I didn't know Clermont specifically was.
Yes, we're like very high elevation, which is the reason why we have that issue with the lightning.
Yeah, and then in addition to that, the click to enter, they did repair it on Friday, actually. I had a couple companies come out to get that taken care of. They replaced the board on 2. I actually have a video of it operating as of Friday. Today, it is open, I'm assuming because you guys tested it. It gets stuck on our concrete, so I have somebody scheduled out to shake down the concrete down. But the operational system, as it's supposed to, the click to enter portion, works.
So at this point now, the only two things that you're not up to code is the doors, the egress doors, and the gate.
The gate is operational. I
We
could
just
take
have
a
to have the
shaper
curb
down. The actual
ground
click to
down a little
enter
bit.
portion works. And it opens and closes, it just gets stuck on the curb, it won't close back, but they have full access in and out, so we leave it open for right now.
Okay.
When will you have the door corrected?
They're scheduled for the end of next week, but they are getting a specific part for it, so I just wanna make sure they have everything done. They ordered a strike plate for it, it's literally just a magnet, that's why it's coming in as a error code on our software.
And that was my question. The city's recommendation was the 15 days to come into compliance until the 30th. You'd indicated in the testimony that that would be sufficient. Do you want to stick by that, or would
We
you?
believe it to be based on what our vendor tells us, but, we ended up here based on what our 3 vendors could do for us and the timeline they could do it, so. If you guys are willing to give us more time, of course, we'd be gracious and accept it, but we understand the seriousness of it, and so we are very motivated to get it 100% rectified as quickly as possible.
I see.
Would I be able to speak?
Yes, ma'am.
When it comes to the access gates, they are not functioning properly as they were designed. We went today, I tried 4 different times to test it. Even as leaving, I tried again. The gates, what's happening is when they're supposed to be closed for access to keep cars that don't need to be there out, and then emergency vehicles are supposed to enter. We have radios, we turn it to TAC 16, we go ahead and click it, and it's supposed to open and remain open for 5 minutes. It remains open for a couple of minutes, and then it shuts, and then it opens, and then it shuts, and this continues over and over again. That is not how it is supposed to function. It is supposed to only stay open the 5 minutes, shut, and only be opened again when we activate it.
Had we been told that they were having an issue when they tested it today, the vendor was on site, so now we've got to get them back out there again.
I see. Okay.
Yes.
So according to the staff, we have the issue with the gate and the egress door, but all the other violations have been corrected?
That's correct.
Okay.
And just to clarify for the board, there were leasing office staff on site today, and I did speak with, I cannot remember her name, but Amanda, thank you. I did speak with Amanda to let her know what issues we found still in need of a correction as of our visit today. So I did notify Amanda that we were seeing some issues with the gate and, of course, the doors.
I would like to ask what the staff recommendation is. You're recommending 15 days?
So the staff recommendation between code enforcement, our fire inspectors, is to have them come into compliance by September 30th, or as of the 1st, to begin fines at $250 per day.
I'm going to make a recommendation that we give them a few more days, especially since you're according to the fire inspector that the gate is still not properly working, and you have to notify your vendor to come and repair this issue. And by repairing it means we don't know if there's other parts that he has to order.
Well, it would be wonderful if we could get the vendor and the Amber or whoever out at the same time, so we can make sure everybody is clear on not saying that you're not being clear, but the guy said it was fixed.
Yeah, I do want to say I did call Amber on Friday and left a voice message. I wasn't able to get a hold of her when the vendor was on site to test it. It was in the afternoon, so I did attempt to have them both on site, but in the future, I'd really like to coordinate to have both.
Oh, I understand. You're depending on somebody else to show up at the time that they say they're going to show up. I understand that. So,
I was thinking you just extend out to October 15th, give it a full 30 days.
that sounds reasonable. Do I have a motion?
Sure, I'll make a motion. Based on the testimony and evidence presented in case number 2500008, I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violations filed in this matter, that I have considered the gravity of the violation and any actions by the violator to correct the violation. I move to order that the respondent correct the violation on or before October 15th, 2025. In order to correct the violation, respondent shall take the remedial actions set forth in the notice of the violation. If the respondent does not comply with this order, a fine of $250 per day will be imposed for each day the violation continues past October 15th, 2025. The respondent is further ordered to contact code enforcement for compliance and to arrange an inspection of the property to verify compliance with this order.
Do I have a second?
I'll second.
All in favor?
Aye.
Though, anyone opposed? Motion approved.
Thank you so much.
Good evening, Board. Andrew Snodgrass, City of Clermont. This is case number C2412-0007. This is for 2434 View Ridge Way. The city code section is 123-74, minimum tree requirements. That is the city ordinance there. This pertains to subsection C. Lots with 4,000 square feet or more landscape space require 2 canopy trees required, and either 1 understory tree or 2 palm trees. This is the location of the property via Lake County Property Appraiser. So a courtesy notice was sent back in December 17th of 2024. Notice of violation was sent out January 21st, 2025. Notice of violation was signed for January 23rd, 2025. Notice of hearing was sent out June 19th. and a notice of hearing was hand-delivered September 3rd. The notice of violations and the notice of hearings kept coming back after the first one was signed for. This was scheduled for other boards, and it was pulled for other boards. The compliance status as of today's hearing is that it is non-compliant. This is the courtesy notice dated December 17th, 2024. The notice of violation dated January 21st. It's the USPS tracking receipt for the notice of violation. This is the notice of hearing and the notice to appear. These were both returned as unsigned. This is the notice to appear and the affidavit of hand delivery, where I hand delivered it to the property. A complaint was received on December 6, 2024. Permit was for a removal of one palm. After a few months, a second palm tree was removed from the property, and no replacement trees have been added. The permit states that the required trees, the permit states the required trees that need to be installed on the property, and the permit was signed for by the owner. This is a May of 2023 picture showing the dead palm that the permit was for. Up on the right side of the screen, you can see the second palm just barely out of the picture there. This is after the one palm was removed. This is December of 2024. This is after the second palm and all the bushes along the side of the home were removed. This is the one tree on the property. It's a little gem magnolia, which constitutes a canopy tree per our ordinance. This is as of July 21st, 2025. It's in the same state, no replacement trees. Again, that's the side of the property. This is as of today. This is just three kind of tight-knit pictures. This is showing the left side, the front, and the back side of the property. As of today, the property is not in compliance. No additional trees have been added. So quick summary, complaint from the HOA in December of 24. Notice is sent and received, but no contact from the owner and no replacement trees. Stopped the property multiple times, left business cards. In April, I began speaking with attorneys dealing with a foreclosure on this property. A resident answered the door finally whenever they were waiting for the water department to arrive regarding a leak. That's the first contact I had with them. After that, about a week later, I was able to hand deliver a hearing notice to the same resident who stated the owner was home but not available to come to the door. So as of today, the property is not in compliance. I have not had any contact with the owner. The staff recommendation is to find the respondent in violation of the section stated and to assess a fine of $150 per day for every day the property remains in violation after November 14th, 2025. Nothing further. If you have any questions for me, I believe the respondent is here as well.
Is the respondent here? State your name and address, please.
Reina Ortega, 2424 View Beach Way, Clermont, Florida, 34711.
Thank you.
Thank you. Yes, good evening. Yes, I just received all the letters and everything, and yes, I'm being through for a hardship. That's the reason that I couldn't replace the palm trees when I removed them. I trying to find a number to buy the trees. It's just who can deliver it to us. And that's the reason that right now I'm passing that in the house is in foreclosure because the business is not, right now is not good for us. I'm working on it and I'm trying to figure it out the way for us to buy a place, to find a place for us to buy the trees and replace it. And working on that too, in order for us to put the house in the best, the best for the house to look good.
I have a question, if I may.
Yes, sir.
Can I ask why it took so long to respond to the attempts being made and not voiced your hardship then before we get all the way to here?
Yes, the thing is that I'm trying to of pay the bills, to be honest. It's the way it's not that I'm trying to avoid it, it's the way that I'm looking for us to pay the bills. And, since it's been hard, I'm trying to, prioritize, some things first.
I understand.
And that's the reason, the main reason. I don't have no excuse for that, but I'm working on that too.
I have a question for staff. Maybe this kind of goes to you as well. There's no requirement for her to go back with the same type of palm tree, is there?
No.
No same caliper?
No, we do have a requirement in our city ordinance for canopy trees and for understory trees. There are two different requirements for those.
And those need to be at what size?
Our canopy trees need to be at 12 feet, and our understories need to be at 8. We do work with people. We understand 12 feet is, as long as it gets close, we're okay with that.
Okay. So in theory, on this one here, she wouldn't even have to go back with, she would only have to go back with one palm and then one canopy, another canopy tree, or is that, did I read that wrong?
I believe she's required to have 2 understories on this one.
2 understory and a palm is considered an understory.
Well, this little gem magnolia on the side here, that is considered a canopy.
Tree.
This says replace with 1 canopy and 1 understory.
Okay.
But if I go back to the, the requirement at the beginning, so lots of 4,000 square feet, she's required to have 2 canopy trees and one understory or 2 palms. So she does require another canopy tree as well.
Right.
Which, with our new ordinance change, that could be a palm tree. It has to be one of the taller palms, like a medjool or date. But
What is it?
That was for special effect.
Thank you.
the measurements, I can provide them to you if you want to provide with an email, or I can drop them off to the property if somebody's going to be home. I can do that tomorrow. I cannot recommend any places. I would just say, please do local and try and go Florida grade. I can't recommend anywhere because they'll say we're getting kickbacks from tree places.
So,
Yeah, at
yeah,
this,
if-
at
if
this
you just-
time, we're not allowed to recommend any places for you. That's, we're not
I would just
supposed to do
say,
that.
please do local and
Yeah, just,
make sure
just
they're,
get on your phone and search
yes.
nursery near me. Yeah, and then, just check a couple places.
So at this, to the staff, at this time, she needs 1 canopy tree, and would be,
No, she has one
an
already.
understory, would be like a palm tree. Would a robolini be like
call
an
'em a canopy.
understory?
We have a list of trees that we accept for understories.
Mhm.
It's a very long list.
And they don't have to be planted in the exact same place?
No, they can be planted anywhere on the property.
Okay, that gives you options. I'm going to make a recommendation to extend it from, the staff had November 15th,
Yes, November 14th.
14th?
Yes, just 60 days.
I'm going to make a recommendation to extend it to December 14th, a month later, give you some, breathing room. This is just a recommendation. The board has to vote on it. Would anyone like to give a motion, or does anyone have any more questions?
I'll make the motion. Okay. Based on the testimony and evidence presented in case C2412-0007, sorry. I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation filed in this matter, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before December 14, 2025. In order to correct the violation, the respondent shall take the remedial action as set forth in the notice of violation. If the respondent does not comply with this order, a fine of $150 will be imposed for each day the violation continues past December 14, 2025. The respondent is further ordered to contact Code Enforcement Office for compliance and to arrange an inspection of the property to verify compliance with this order.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? Motion passed. You're welcome.
That's gonna be a fun one.
All right, this is case number C2505-0017. It's 268 270 East Avenue, New Beginnings, Central Florida. This was a health, safety, and welfare complaint. This is City Code sections, International Property Maintenance Code 109.13, structure unfit for human occupancy. IPMC 109.1.5, hazardous structure or premise. IPMC 302.6, exhaust vents. IPMC 304.13, window skylights and door frames. IPMC 305.1, general interior. IPMC 305.3, interior surfaces. IPMC 403.5, clothes dryer exhaust. 501.2, plumbing responsibility. 504.1, general plumbing. 605.1, installation, electrical equipment. Section 1853, subsection 6, odors and stenches. 1854, creation or maintenance of nuisance by property owner. And 1853, subsection 4, dilapidated buildings. Just leave these on for a second. I won't bore y'all with reading through all of those. Those are the ordinances and the codes laid out. So this is the location of the property via Lake County Property Appraiser. So a complaint was received on May 23rd, 2025. A notice of violation was hand-delivered August 11th, 2025. Notice of hearing sent August 26th, 2025. This is the notice of violation dated August 11th. The compliance date, if you'll notice, is also 8/11. This is a health, safety, welfare. No time to correct was provided. Affidavit of hand delivery of the notice of violation. This is the notice to appear. Tracking receipt for the hearing notice. So this is a picture of the garage ceiling. On the left is, well, this is both a kid's bedroom. As you can see, there's water damage in the property. If I might add, this complaint was received in May. The tenants were removed from the property, put in a hotel for 27 days while professional repairs were done on the property. This is after these repairs were done. This is after. Yes, sir. This is after, per the owner, $40,000 worth of interior repairs were done. So this is the ceiling in one of the kids' bedrooms, the door frame, which it looks like it's just the trim, but it's actually doors separated from the frame. This is a door leading to the garage, the outside. Doesn't seal on the top. There's a hole in the bottom. I was told that was cut by a previous tenant for an extension cord to run through. These are smoke alarms missing. The bottom right picture is in the garage. That's live wires exposed. The top right picture is a non-GFI outlet right next to the bathroom sink. Picture on the left. Yes, you had a question? Go back. What was that bottom left picture? Bottom left picture is a smoke alarm, where a smoke alarm should be in the garage. Both those pictures on the left are both smoke alarms that were not in place. The picture on the left here is the dryer for the property. There is no vent leading to the outside. Tenants were told to simply open the garage door and let it vent that way. Hot water heater on the right. There is no hot water expansion. There's also a drip leg that is not long enough. There's no permits for that. There's a drain coming from a washer that was removed. That drain goes to the outside. Not sure where that goes. Light on the left is in a kitchen there's just a duplex, 268, 270. The one on the left is in 270's kitchen. Water was coming through that light. Again, water stains on the right next to the smoke alarm there. This is more damage from the ceiling in the kids' room. On the right side, that used to be just a patio type of area. It was all enclosed. Plexiglass was added to the outside, preventing egress through any of those windows. That is now a child's bedroom. These rooms here. That plexiglass is screwed into the exterior walls, preventing egress. Yes, it's screwed into. They do now. That has been repaired. One of those windows was removed and had a regular window installed, but the other windows still have the plexiglass on them. That was like that for many years. This is a door leading from the garage to the back of the property. As you can see, it's obviously not airtight, not sealed. Picture on the right, I can put my hand around it and pull. It's the hallway where that door would lead to, leading to the backyard. The picture on the right is, I'm not sure when that was added, but that is an added sewer line. That sewer line is sitting on some bricks and some sandbags. The picture on the right looks like a candle and a brick. The elevation of that sewer line is actually leading back towards the house, so gravity is not allowing that to drain to the city cleanout. It's actually draining back towards the home. Sorry, that picture below there is just a close-up of the live wires out of the garage. This is a picture of, in 270, the rear kid's bedroom. This is a separate bedroom from that first one. This is when the roof was, there was a new roof on the property. When that was installed, the roofer stepped through the ceiling. As you can see, there's lots of water damage. That ceiling had to be pretty soft. This is below the sink in a 270. You can see the water is standing below there. You can see the repairs, duct tape on the walls to seal it in. These are lines that were added to the kitchen, kind of out through the attic.
Are those water lines?
Yes, they are water lines. 2 new air conditioners that were installed within the last few years. No permits were pulled for those. Vale Plumbing is currently working on getting those corrected. So a moisture meter is something that we use on walls if we think they have moisture in them. Anything over 15%, I believe Mr. Cornett can kind of testify that anything over 15% is considered something to look at. 81.2 on the left, 84.4 on the right percent. It's a little bit higher than 15. 36.9, 42.1. This is a follow-up inspection as of today. Today, the repairs are pretty much finished, minus a few permits. I haven't checked the sewer line to see if it is elevated back. One of the main issues on this property was the mold. There was a mold report done by tenant in 268. We did get that mold report. Based on that mold report, the property was tagged as uninhabitable, unsafe.
I have a question.
Yes, ma'am.
In this picture, the one on the left.
One on the left is the original.
Oh, that's, okay. That's the water damage.
Yes, I
Okay. And
apologize.
then
One on the
right-
left is the original. The one on the right was from today after the repairs were completed.
It appears there still seems to be some kind of water damage, or?
Yes, ma'am, it does.
Okay.
I'm sorry, the home was placarded as unsafe after my first inspection due to the mold report, due to the obnoxious odor inside the home, due to the sewer lines and due to the smoke alarms. So, picture on the left shows the original. Picture on the right shows the repair as of today. I'm not sure if it looks like that. Looks like that plywood is, yes, it does. This is the post-remediation verification report from Florida Mold Services. After mold remediation is done, the company will go in and provide like an AAR, like an after-action review. They'll give a report. As of the 11th, I believe this was taken, the home is acceptable as far as the levels of fungal spores and particulates. The placard on the home has been lifted, so the residents are able to go into the home per code enforcement. So this is an email from the tenant. She was not from the tenant in 268. Apologize, that says 269. She's not available this evening, so she requested that this be posted. Just a quick timeline of her time with the property. I'll give you all a second to read that. There are 3 pages of this.
Is the home by code, is the home habitable?
I did just learn today that there's no hot water in the home, which would make the home uninhabitable.
And the amount of moisture in there is still the same?
I did not test any moisture today because they were in there freshly painting. I didn't want to get that. That would affect the meter.
Would that
So I didn't want to
high
get
amount of
incorrect
moisture,
readings.
Would that indicate mold?
The high amount of moisture would indicate the great location for mold growth. I can't say that high moisture does indicate mold, but the mold test did indicate mold.
Would provide would be a conducive environment for the growth of mold.
Yes.
I would think so. I
Yes.
just want to make sure we've got that on record.
Yes.
Yes.
Improvised sewer line is still there?
That is there. It is allowed. Yes, it is allowed. There are certain recommendations or certain requirements. As every 4 feet, it needs to be strapped to the wall. It does need to be at a certain angle. Yes, the grade has to be correct.
And what about that sewer line?
That's what we're speaking of. Yes.
Oh.
So it is strapped every 4 feet currently. I did not have a level out there today to check to see which way it is angled. So I will be going back to the property to measure the moisture and to check the level of that sewer. Yes, ma'am.
Now, I'm also curious, those lines that use the 1-inch pipes that were going up into the building, and you said those were water lines?
Yes, ma'am.
Is that allowed?
Yes. It's not best management practices. That is PVC sitting outside. It is allowed. Yes, ma'am. This goes to June and July for the tenant at 268.
I'd like to ask, is there a representative for New Beginnings?
I don't believe there is a representative from New Beginnings here. They have not showed up this evening.
Is there anyone here who wishes to speak about this property? Please step forward, state your name and address.
Let me run through this if you don't mind real quick.
Okay.
We finished up August and September. So just real quick through those. This is a email from the Infinite Helping Hand Center. They're the ones who placed one of the tenants with New Beginnings. Earlier this year, they placed Kirkland's family in the hand of New Beginnings, believing they would receive safety, dignity, support. This talks about mold infestation, structural decay, unsafe electrical systems, plumbing. Newly surfaced documentation reveals even more disturbing truths. The tenants are facing unlawful eviction per this email. A 3-day notice, which was posted on the door this today whenever I went by. And then I do have one more. This is an email from Corinne Husko. Again, just talking about the housing conditions and displacements from the home and financial issues. So I'm going to move on to staff recommendation is to find the respondent violations of sections stated, to assess a fine of $150 per day for every day the property remains in violation after October 15th, 2025. I will reiterate that as of today, minus the sewer, the health, safety, welfare conditions have been are in compliance. They have
So
been
the city is not requesting a health and safety tag?
We still are, due to the sewer line, yes. And due to the ongoing outstanding violations.
State your name and address, please.
Nadine Curry. My address is 803 North St. Clair Abrams Avenue, Tavares, Florida, 32778. And that statement is actually from me. I'm the co-founder of the Helping Hands Center, together with my mother. And unfortunately, yes, we thought that New Beginnings was going to help Kirkland and her family. But besides that statement, I've also learned, I was doing research while at work because I intended on coming over here, that Mr. or whoever at New Beginnings bought this parcel for $10 in 2015, I believe. There's no permits for construction, for turning it into a habitable place. And it was originally classified as 6 rooms, no bathrooms. So if you don't have a permit, how did the bathrooms come into play into that house? That's number one. And number two, it cost $10 back in 2015. And you can see why, if you go into the public records, why it cost $10. Because these issues were already being caused by, or they were already there.
Existed. They already existed.
But at the time of the purchase, the property was uninhabitable with no functioning bathrooms, and its deteriorated state was known to New Beginnings. Yet instead of restoring it to livable standards, they placed vulnerable families and charged them rent. The deed confirms that the property includes lots 5, 6, and the north half of lot 7 in block 4 of Sunset Heights. This is basically that 268 and 270. This is not leased land. It is owned outright by New Beginnings, and therefore the organization bears full accountability for its condition. Furthermore, no legal permits were filed for the construction of reservations claimed by New Beginnings. The so-called repairs, including roofing, mold, remediation, and structural work, were conducted without oversight, without licensed professionals, and without compliance with Florida building codes. Despite this ownership and responsibility over decades, or at least a decade, right? The property was allowed to deteriorate to the point of condemnation. The mold, structural decay, and unsafe systems were not inherited, they were neglected. So this is to say that he put these people into this home, knowing it was already neglected for over 10 years. And the families who lived there were not guests, they were tenants, paying rent to an organization that failed to meet even the most basic standards of habitability. Now, unfortunately, Kirkland faces unlawful eviction. He basically just pulled something off the internet, I think, and without a court-ordered eviction, he just, something you can just Google and say, or AI can print something out and say, you're evicted. Basically, that's what he did. I have pictures of that, but I can't really show them, sorry. So, no court order has been filed. Kirkland is not refusing to leave. She simply cannot afford to, because, I think everybody can understand with the kids and living in a hotel from hotel to hotel, and working in Clermont and having kids in Clermont while living in Kissimmee, and then moving them from hotel to hotel, there's a lot of expenses that come with that. And right now, I am beside myself at what New Beginnings is doing to Kirkland. And the other tenant has already found a place, and lucky for her, she got the money, I don't know how, but there's no way for Kirkland to pay for a new apartment or to, there's just no way for her to move into a new apartment, which is what they're making her do.
She's no longer paying rent.
She wasn't paying rent during the times in the hotel because she's in the hotel, so that's still going on. Except for what I learned today, even though I actually passed by the house myself just to see. I didn't stop, but I did take a little video just to see if what was done.
Okay.
So Ms. Curry, could you give us a little backstory on what it is that New Beginnings does that you would put place of family with them?
So what I had understood that they do is they place families in transitional homes and then later and put them in certain programs, whether they be recovery programs, like if you're an alcoholic, they put you in, you know, or NA or something like that. And they have like programs, thrift stores. I just figured that they would be, besides, I contacted Samaritan in Leesburg first, because they do the same thing, they do transitional housing. And me and my mom are the only ones in our organization, so that's not, you know, we don't have, I mean, we're trying to help people, but with guidance. So I guided them into the beginnings, and that was all just going by what I had read.
Right, yeah, you're just making recommendations of these are the services that are out there, here's who you need to contact, so, yeah.
Yeah, exactly. And I went through a lot of services, and New Beginnings was the first one to actually listen to Kirkland and help her out.
And they're a nonprofit too, right?
Yeah.
That's what I thought so.
Yeah, but they're getting a lot of profit. That's really all I have to say, because I'm beside myself, and
I want to clarify, I went to New Beginnings for situational homelessness. It had nothing to do with drugs, had nothing to do with alcohol, had nothing to do with any kind of mistakes that I just continuously kept making, not learning my lesson. My husband died, we became homeless, we went to New Beginnings, that's how that happened. I've got 4 small children, 2 of them are not that small, but they're back there, and I've got 2 little girls. Of course, you can't do that living on the streets. You can't have little girls and boys living on the street. I would first say I'm very, very, very grateful for the intent of New Beginnings. It's been thrown around a lot, but I'm just ungrateful, and that's not the case. It's absolutely not the case. I spoke at the gala. I spoke at a couple other nice events to try to help them bring in money, okay? I also found out from their trusted employee that my rent money has been classified as donations, and that I was apparently the biggest donator for the entire time, which means, of course, no profit being made. No profit being made. And the entire time, my ceiling's literally falling in. We come home if it's raining and we're sliding across the floor on the strip across the ceiling. It holds it together. We have broken tiles that my kids are cutting their feet on. We have snakes all over our backyard because I don't mind cutting the grass, but they wouldn't let me. It was in the lease, they were gonna do it. I've asked and asked and asked, if they won't allow it. I got ignored for months about it. Now, the saddest part of the situation right now is that now I'm being evicted for what? not to pay rent while I was in a hotel. When we were in Kissimmee, I was told not to pay rent. I'm doing the same exact thing that I was instructed to do. And now they're trying to get me with a 3-day notice for $2,900, which is absolutely ridiculous. I paid my rent the week before I went into the hotel, not realizing I was gonna have to go in there. And I just didn't pay all of it while I was in there. That's it. And I've also paid at least 3 of every 7 days out of pocket with the help of Sharon from Rose of Sharon Ministries. I'm definitely gonna try to find a place to stay, but I don't even know where to start at this point. You know, there's a lot of responsibilities, a lot of moving parts going on in my life, you know. So I'm trying to figure that out, but I will say too, that upon moving into the house, Jenny said, it's an old house, we just have to work out the kinks. I was homeless, I didn't even know what that meant, and to be honest with you, I was in a desperate situation, okay? But I didn't realize she meant that it was toxic mold. My kids are still sick, getting over it. So, and that's from, I have multiple, I have like 100 pages printed out of screenshots of me bringing the problems up to New Beginnings. Multiple people within New Beginnings. And they're saying that I never told them about the mess, or about the problems. Well, I have proof that I've done that. I mean, there's pages and pages of proof. So they're trying to make this, an email that I received, they're trying to make this how all this damage is my fault. Well, it's not possible, because the previous tenant, who I do speak to regularly, said she was gonna come tonight, but she must have had something come up. She has hundreds of pictures that have been shared, these same exact problems within that home that I deal with now, except they're a little bit worse. It's just completely gone. The picture of our roof as they were fixing it, they fell through my son's ceiling because there was literal holes in the roof. Like, and the guy who owns Koala told a friend of mine that he told Steve 10 years ago that roof needed to be replaced. Meanwhile, we're living in it, breathing in mold, and I have a compromised daughter. I mean, if they couldn't have helped me, they just could have told me they couldn't help me. You know?
I understand.
Thank you.
If I can add to, speaking with the Lake County property appraiser, who does home quality service inspections under the HUD program under Section 8 for Lake County. This house was previously on the cash voucher program under HUD for the previous tenant that Ms. Kirkland spoke about. And I've been trying to pull the records from Lake County. I haven't got that record request back yet, but I spoke with the inspector directly, and she did confirm that the house is pretty much in the same condition as it was in April of 2024.
It was mentioned by one of the respondents about overgrowth of the property. Is that also one of the violations? Because there's just so many violations in there, I don't remember.
Mold?
Was that also in there where it's overgrown?
Overgrowth?
Yes.
Oh, sorry.
Overgrowth of the weeds backyard that
Right.
she was referring to about.
No, that is not part of one of the violations. No.
Okay. Could you,
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Okay. If you'll just give your name and address.
My name is Sharon Conte at 253 Cedar Street, Clermont. I own Rose of Sharon Ministries, Homelessness and Outreach Ministry. I've helped her stay in the Wood Spring Suites because she was all upset. I've known her for a couple of years. She was all upset because they didn't give her enough money to stay in, what is it, right, Ryan? Statebridge, whatever. They were putting them both up in the hotel, and I know both of them. So, like 8 o'clock at night, she had nowhere to go. They said that she was evicted from there. He wasn't gonna pay for them to stay there any longer. And I brought her over to Wood Spring Suites, and I paid for about 5 nights, because the money that he was gonna, or they were going to pay for the hotel was always short. And I have no place for her to go. And my only issue with this place is that I did some research, in 2014, there was a Mark Ball that owned the place. City of Clermont Minutes Code Enforcement Board, January 21, 2014, 108.1.4, unlawful structure, section 66-7, tampering with property of city water or sewer system. And I couldn't find any permits ever pulled for this place. 260, it was actually, I found it under 270, I believe, because it's not a legal duplex. It was never turned into a legal duplex according to these records, so. I just question the validity of the place being rented as a duplex. Are there any permits that were ever pulled for it?
None that I have found, no.
Excuse me?
None that I have found, no.
I don't have anything else to say.
Thank you. I'd like to hear what the staff recommendation is for this issue.
Staff recommendation is to assess a fine of $150 per day for every day the property remains in violation after October 15th, 2025. Due to,
With the health and safety tag, right?
with the health and safety, yes, health, safety, welfare tag.
Does anyone else on the board have a question or a recommendation?
My thought would probably be to reduce the time that they need to
That
bring
was
it
my
into
thought, too.
compliance. I mean, I would 10 days.
May I get a motion?
I'll make a motion. Based on the testimony and evidence presented in case C 2505-0017, I move to find that the respondent is in violation of the City of Clermont's Code of Ordinances as listed in the notice of violation, that I have considered the gravity of the violation, any actions by the violator to correct the violation, and any previous violations by the violator. I move to order that the respondent correct the violation on or before September 25th, 2025. In order to correct the violation, the respondent shall take the remedial action set forth in the notice of violation. If the respondent does not comply with this order, a fine of $150 will be imposed for each day the violation continues past September 25th, 2025. The respondent is further ordered to contact the code enforcement inspector to arrange for an inspection of the property to verify compliance with this order. I further move that the board finds that the violation presents a serious threat to the public health, safety, and welfare, and it is further ordered that by copy of this order, the City of Clermont be notified of said condition pursuant to Section 162.06, Section 4, and Section 162-09, subsection 1, Florida statutes.
Do I have a second?
I'll second that.
All in favor?
Aye.
Aye. Any opposed? Didn't think so.
Thank you,
Motion
Board.
passed.
We still have the the first item, which was tabled to the last part. No respondents have showed up. That was for Colonial Tile and Pavers, item 1, fine reduction.
If I'm not mistaken, I believe there was representatives from Colonial Tile Pavers at our last meeting.
Yes.
Madam Chair?
Indeed.
Yes.
Just for purposes of the record, did it say somebody signed in earlier today?
Give me one moment and I'll confirm.
Madam Chair, I believe they were here 2 meetings ago?
Yes, I believe that was in March.
Yes, the March.
Yes.
Oh, so they did not sign in? Okay, all right, so hypothetically, if they had signed in, what I was gonna do is a hallway sounding and then state for the record they were not present. So, don't need to do that. But I assume the city is not asking the board to take any action with respect to this item?
Correct.
All right. So if it comes back to you, they'll notice it at another agenda, but there's no motion of any kind that needs to be made.
Okay. So my question is this, are we going to postpone this to the next meeting?
I will reach out to the respondent and see if they want to be on the schedule for the next meeting, and
Okay, and then we'll make a decision then.
yes, ma'am.
Okay, I'm good with that. that concludes all our,
Okay, make a motion to adjourn.
yes.
We do have to just, for the record, say if anyone's here for public comment for non-agenda items, if they wish to address the board, now would be the time to do so. Seeing
Is
none.
there anyone here that would like to make a comment?
Motion to adjourn.
Second? All in favor?
Aye.
Aye.